So good evening, everyone, and welcome to the Faculty of Laws at UCL. I'm Dr. Danaya Zari. I'm Associate Professor at UCL Laws and co-convener of the lecture series of the International Law Association, the ILA. Now, before presenting our speaker, I would like to say a few words about the ILA lecture series at UCL. This is a series that has been running in the past 15 years with the aim and vision to provide a forum where major debates in the field of public international law openly take place with academics, practitioners, our students, and the wider public. Tonight's ILA lecture is also a joint event with UCL's Human Rights Institute, and I can see also the director of the institute in the audience. Thank you very much, Veronica, for coming. As a member of the institute myself, and since this is a joint event, I would like to say a few words also about the institute. The Institute is a multidisciplinary center for promoting academic impact on global human rights issues. And it is thus no surprise that the ILA lecture series at UCL and UCL's Human Rights Institute have joined forces behind tonight's groundbreaking lecture by our esteemed colleague, Professor Yuval Shani. Now, Professor Shani does not need really any introduction. I will keep my presentation of his biography very brief. Professor Shani is the Hirsch Lauterbach Chair in International Law and former Dean of the Law Faculty of the Hebrew University of Jerusalem. He was a member of the United Nations Human Rights Committee from 2013 to 2020 and has served between 2018 to 2019 as chair of the committee. He currently teaches at the Center for Transnational Legal Studies at King's College London, and is a visiting research fellow at the Ethics and AI Institute at the University of Oxford. Now, his lecture tonight is entitled The Three Generations of Digital Human Rights, a topic that is both topical and thought-provoking. So without further ado, I pass the floor to you, Yuval.
Thank you, Danae. Thank you for inviting me to be in this important lecture series, and thank you all for coming. So in terms of thought-provoking, this lecture deals with a chronic problem that we have in law, and that is, how does law react to changing circumstances? This is, of course, not a new problem, but we are confronted, I guess, with this general question in recent years in a very intensive manner, given the very fast pace in which technology is changing. And the next slide will give you a sense of how dynamic is this field, this idea that we need to do something in order to adapt human rights, which in and of themselves are something new in the international arena from a historical perspective. They've been with us only since World War II in the full sense of the word, but there is a strong sense that I don't know whether the lecture is groundbreaking, but the earth underneath our feet is somewhat shaking. The tectonic plates of the world we live in many respects, including in the field of society, technology, governance, etc., and that human rights law has a role to play. And even in the last couple of years, sometimes even a couple of months, we have seen attempts to try to adapt, or at least to say something meaningful about the need to adapt human rights law to this changing reality. So the Global Compact is an agreement reached by all states this September at the General Assembly as part of the Summit for the Future, which was held with the presence of the high-ranking leaders. But we've also seen the White House issuing 2 years ago a blueprint for an AI Bill of Rights. We have seen the European Union adopt also 2 years ago a declaration on digital rights and principles for the digital decade. The African Union has adopted recently a digital compact. We have seen this September was a heavy month. We've also seen the Council of Europe adopt a new treaty, a new convention on AI, human rights, democracy, and the rule of law. So I would stipulate that this is a field of human rights law where developments are occurring at a relatively fast pace. And that can be juxtaposed against other areas of international human rights law, where we are seeing states struggling to create new laws. And in fact, we haven't seen major new human rights treaties at the global level in the past 15 years. So we are actually seeing something quite different in terms of the ways in which lawmakers are reacting to this changed reality. As I will try to explain in my talk, those reactions themselves can be critically analyzed, and I will try to do that to some extent. But before digging in deeper into some of the main instruments and some of the main ideas that they put on the table, the question that I am dealing with, that is the adaptation of international human rights law to changes with digital technology, is a somewhat new and innovative question within human rights law, but it is not a very new and innovative question for law more generally. Because at least since the 1990s, when the internet became a somewhat of a household commodity, questions started arising as to how does domestic law apply with regard to what has been at that time regarded the law of the internet. And there has been in the early 1990s or in the mid 1990s, there has been quite a robust debate in academia, in the legal profession, but also in the broader field of public debate, as to whether the internet, this idea that we have a body, we have certain interactions that do not attach to territory, and we have an infrastructure that is not controlled by a government, whether this in a way renders transactions that take place on the internet as removed from the jurisdiction of states. And there has been this idea that we have something which is quite unique, a new legal domain. We even have a Declaration of Independence issued by John Perry Barlow, alluding that cyberspace is an independent domain in a way like outer space, where governments do not have a regulatory role. But as you can imagine, there has been a significant pushback on the part of governments, and at least that debate, as a practical matter, had been settled, and domestic laws found ways to address a variety of legal issues that arise in the internet. The metaphor that is used in this regard is sometimes the law of the horse metaphor that those of you who have studied law and technology must be familiar with ad nauseum. And that is the idea that we do not have to develop new law every time that we have a change in technology. So when horses started to actually run on the streets and carry carriages with them, we did not invent a law of the horse. Okay, and when the horses were substituted by cars, we simply took the laws that we had for horses, and by way of adjustment, we applied them to cars. And the argument goes that this is the same fate that awaits our new technology. We do not need to reinvent the wheel every time a wheel is reinvented. That's essentially the argument that is being argued. Now, this debate is a debate that exists also at some level at the international field. We do see this as a live debate in international academia, but also within international decision-making fora. And I would argue that the dominant approach that we are seeing so far has been that the same idea, the same law of the horse philosophy that we applied with regard to new developments in the domestic law sphere is being now transposed to the international sphere under the theory, not exactly that nothing new, there is nothing new under the sun, but rather that we do have within existing laws, including within existing human rights laws, sufficient tools, a sufficiently robust and sophisticated vocabulary to deal with new developments in technology. And the main mantra that we hear in that regard is the mantra that I and a PhD student of mine, with whom I've written a paper on this, called Daphna Drozd-Polensky, we have to call this framework as the normative equivalency or the normative equivalent paradigm that asserts that the same laws that apply offline would apply with some minor adjustments also online. And as a result, the human rights that we have in an offline context, freedom of expression, privacy, equality, etc., they would also apply to our activities online. And if I've mentioned before the Global Compact from September of this year, I would say that the Global Compact adopts a similar framework of analysis. So if we look at paragraph 8C of the Global Compact that deals with the objectives of the Global Compact, the language that is used here is that the compact is anchored in international law, including international human rights law, ergo existing international law, existing international human rights law, and then you have this, well, I've put it in bold, this more stronger rhetoric, all human rights, including civil, political, economic, social, and cultural rights and fundamental freedoms must be respected, protected, and promoted online and offline. So, so the major point of departure, I would argue, for mainstream international law is that rights that apply offline also apply online. Now, the Global Compact acknowledges, as do most academics and practitioners and policymakers working in this field, that there are unique challenges that digital technology brings about with it. Some of these challenges could be described as threats. So the digital environment, for instance, could put children in certain risk of exploitation, new risk factors for child exploitation that did not exist before or did not exist in the same configuration or even intensity in the offline world. Hence, we would need to find specific adaptations, be them technological solutions or minor adjustments in legislation or ways of regulating technology in order to deal with these new threats. But at the same time, there is also a parallel narrative, which is a narrative that is quite, I think, important and significant, and we often tend to downplay its importance, and that is that new technology also brings with it new opportunities for the enjoyment of human rights. It can render educational, for instance, more accessible to millions of people, and therefore render the right to education, which is an important economic, social, and cultural right, much more affordable, much more feasible, and of course the list goes on and on. So I would say one idea is that there is normative equivalence. The second idea is that technology is a mixed blessing from a human rights point of view. It's not all negative, but even the negative aspects could be more or less addressed and confronted within the existing framework. And indeed, the third idea, I would say, that the Global Compact represents, and I'm using the Global Compact because It's a recent and it's a rather relatively authoritative statement, because this is a statement that all states have signed onto, and it in a way builds on a very long list of General Assembly and Human Rights Council resolutions that more or less go in the same direction. So the third, I would say, article of faith is that we are going, in order to deal, to basically implement human rights in the digital age, we will rely on existing institutions. So we go, where do we deal with human rights at the global level? We go to the UN. And the UN as an apparatus, quite significant apparatus, sophisticated, with many bodies, many institutions, and they are in a position to render advice, advisory services on human rights in the digital space, but also they're able to harness their existing mechanisms for enforcing human rights in the digital age. And the focal point that is mentioned in the Global Compact is the human rights, the United Nations High Commissioner for Human Rights. Another mechanism that is, of course, very important for the actual implementation of human rights is state law. And the Global Compact also calls on states, it's up here at section A of paragraph 23, to ensure that national legislation that is passed to regulate technology is compatible with human rights law. So we basically refer to the existing building blocks that we have for the human rights system, which is states and the UN, in order to develop and to implement human rights for the digital age. The one area where I think we are seeing within the Global Compact a certain acknowledgement that things are somewhat more complicated, and therefore we would need to not only apply the same frameworks that we have, but rather extend existing framework, has to do with the business and human rights framework. Of course, in this sphere of activity, and I will elaborate on this shortly, businesses are extremely central to the development, dissemination, monitoring over technology. We know that we have within the UN a framework to deal with business and human rights. These are the United Nations Guiding Principles for Business and Human Rights from 2011. And what the Global Digital Compact essentially does is calls on the private sector to apply the United Nations Guiding Principles on Business and Human Rights. And then it replicates some of the language that is used in the Guiding Principles, which is call on companies and developers to respect human rights, which is the central normative duty that the Guiding Principles impose on companies, the responsibility to respect, and then also to provide access to effective remedies, again, in line with the UNGP. So I would say that this is the fact that it is singled out and that there is relatively more language on business and human rights than there is on state legislation, perhaps reflects this idea that this is where maybe the gravity of the regime would have to somewhat migrate from states and the UN more towards this soft law framework of application with regard to businesses and human rights. The big question is, will this work? Will this approach work? And as you can perhaps guess, I have some doubts whether it would work. I'm not, to be clear, I don't have anything bad to say about what's in the Global Compact. I think all of these ideas, they're good, they're important, they're useful. The question is whether they're sufficient to deal with the challenge that we would need to deal, and the concerns that critics like myself and others have with regard to this business as usual framework of analysis is that there are some key differences, some key elements in what we are seeing around digital technology, especially in the last 15, 20 years, which is putting in question the suitability, the fit of the existing framework that was created in 1945 to regulate state power and to protect individuals from certain historical risks and to provide with them certain development-related opportunities, and to basically cut and paste this framework and apply it with slight modifications to a very different set of challenges and opportunities, that might not be enough. And I don't have a lot of time. I would just mention that we are, and there is a very rich body of literature that deals with these. Okay, no, I don't worry. I still have a lot to say as well. So the idea of territory, okay, human rights were built in the way they were configured, the international law system, they were configured around the idea of state territory. A state, so the world is divided into these building blocks, these states, and each state assumes responsibility for transactions for individuals who are situated within its territory. Now, there is, of course, this idea of extraterritorial jurisdiction. I've written a little bit on that, but this is still the exception to the rule. The rule is territorial jurisdiction. And the whole frame of mind, the whole division of labor between states is built on this idea that states have primary responsibility for regulating transactions and protecting individuals within their territory. The question is, what happens when you have a technology that doesn't really respect the boundaries of territory? I mean, this whole idea of data localization, which is something that states are very interested in, is a response to this idea that data, which sits on the cloud in Ireland or what have you, and then accessed from all over the world, the data itself is not territorialized. And if the judge in the UK wants to see the data that is on the on Facebook server, they would have to basically ask typically for judicial cooperation and assistance from another country. So the ability of countries to actually exercise their responsibility vis-a-vis transactions and individuals in a world where the data, the technology, the wires, the wavelengths, the intellectual property is not actually located in this or the other place. This is a significant problem. We are seeing somewhat parallel questions in environmental law. You'd say this is not unique to technology, but in a way for technology, it's even more dramatic, because even identifying the source where actually the information emanates from is something which is very difficult to establish. The other idea here is the decentralization. Again, when we established human rights law in 1945, we had a very strong notion that the state is the sun in our legal universe. In the state is responsible for legislation, namely for standard setting. The state is responsible for resolving disputes with court system. The state is responsible for executing judgments, for implementing laws. It's increasingly questionable whether this is the reality that we are facing in a digital context, whether it is the state that is, for instance, blocking Donald Trump from calling on his supporters to go to Capitol Hill and overthrow the government, or whether it's a private company. In this specific incident, a specific person, Mark Zuckerberg, who has on his own Facebook page issued a decision to block Trump. So the idea is that the traditional functions of government have been, in a way, decentralized. They have been delegated. They have been removed to private companies, and the state is no longer sitting in the driver's seat of developing technology, but also standard setting around technology. It's increasingly the companies themselves. It's the engineers who are working in these companies. It's the legal advisors sometimes in these companies that are setting standards for the industry, ergo for the world. So the state has lost its central power, its central authority in the world of law, which is again putting in question the applicability of traditional human rights law to this new reality. Globalization, that's of course goes without saying. We are dealing here with companies and with technology that is applied on a global scale, and it is very doubtful whether any specific state can regulate these companies, because these companies, they do not operate in a single state. They are global companies. They operate around the world. And therefore, it's not clear even under which jurisdiction their operations are governed, by which jurisdiction. So Facebook has, I'm picking on Facebook just because it comes to my mind, and but the same applies to the other companies as well. So they have headquarters in one country, but they have offices in many other countries. The Facebook Oversight Board, which is the complaint mechanism, is based here in London. The cloud is based in Ireland, and the list goes on. And there is really also a question of the practical ability of states even to regulate these companies. So maybe the EU can impose significant fines on Google. But can El Salvador do that? Or can Lithuania, well, it's the EU, but can the world is becoming, can Mongolia do that? Yeah, I have to find some new domains. So small, mid-level countries cannot afford. I mean, even China, Facebook doesn't work in China, because they're not willing to subject themselves to Chinese regulations. So you do have here significant questions, and this is encapsulated by the idea of too large and too global to be regulated. So that's also a practical concern about whether human rights law can actually do the work, given the power relations that we now have. States have lost not only their monopoly over standard setting, they've also lost some of their actual power. You have here this chart, I don't know if you can see. So these are the GDPs of countries and companies. So you see the UK immediately afterwards, Apple, Microsoft, Canada, Italy, Google, Australia, Amazon, Mexico, etc., etc. And that gives you some sense of what are we talking about in terms of the economic progress of these companies. And the question is whether a country here, small country like Sweden, can deal with a giant like Apple that has four times the size of its economy. These are significant questions that we have to deal with when we are thinking seriously about regulating these companies through the avenues of human rights law that have these states and the UN special rapporteur for this or that going to tell the company what to do. It doesn't seem anymore to reflect the economic and geopolitical reality that we are facing. Digital divide is an additional issue which I'm flagging because digital divide raises serious human rights issues, but I think it also raises the question of whether we are talking here about a body of law which is truly universal. I mean, it should be truly universal. But when we have significant gaps in access to technology between different countries, there is a risk, and this risk is real, that standard setting would not be actually dominated or would not be actually led by countries that do not have even access to that technology. They're located in a different point on the spectrum of access to technology. And therefore, when we are thinking, for instance, I'll talk in a bit about the right to a human decision maker as a right that has to do with AI regulation. In some respects, this is meaningless for countries that don't have access to AI technology at this point in time at all. So there is also a question of synchronicity. How do you synchronize the regulation? And international human rights law takes the view that these norms are norms that are universally applicable. Human rights are universal. And here you have a state of technology that is certainly not universal. you have significant gaps, and that reflects on the legitimacy of even advancing some of the regulatory projects through the language of human rights law. And finally, there is this specific question about mechanisms, which I flagged, and that is, I mean, the human rights mechanisms, and like Dana said, I served on one of these on the Human Rights Committee. I'm a big fan of the human rights treaty bodies. I think they do a very important job, but you have to realize that almost everything they do is irrelevant to kind of the issues we are dealing with, because they're only monitoring states. They have been constituted as bodies that are that basically provide monitoring services with regard to states. They do not have the jurisdiction, of course, they don't even have the capacity to effectively monitor states, but they certainly do not have the capacity to monitor companies. So what you have is like bits and pieces. So you would have the working group on business and human rights, which is trying very hard to deal with these issues. They will send a letter to a company and would ask the company to provide information about a certain problem that was brought to their attention, and then 50% of the time the company will not respond at all. And in the other cases, they will basically give a very simple or very evasive answer. So to think of these mechanisms in any stretch of the imagination as effective mechanisms for technology companies is not very serious. So these are, I think, the kind of issues that I think challenge the normative equivalence paradigm and basically put in question the sufficiency of that paradigm. In order to present things in a bit more balanced way, I would say that the human rights law has learned over time to somewhat improve its performance in some critical areas so as to reduce the gaps that exist between the traditional human rights law and the human rights law we arguably need in order to deal with this new technology. And I'm noting here on the slide, I am conscious of time. Okay. And because the lecture is on 3 generations and we haven't really reached generation 1, so I'm a bit mindful of this. It will be a bit disappointing if we don't mention the word generations.
Is it the right one?
Sorry?
Is it the correct one?
No. Right, this is the right slide.
Yes.
Right. Thank you for this. Yeah, what were these adjustments? And these adjustments are all very important, but I would argue that they still have not resolved the problem. So extraterritoriality, yes, we've seen some movement. We have seen human rights bodies become more flexible with regard to extraterritoriality. So this idea that state only what happens within a state is relevant is somewhat has become a bit more flexible, and even the European Court, which has been in a way probably the more conservative body on this issue, has relented recently and accepted that the idea that data could actually attract jurisdiction. So if the UK, this is a case against the UK from last year, if the UK has been able to put its hands, metaphorical hands, on data belonging to an American citizen and to an Italian citizen in the specific facts of the case, then even though they have never set foot in the UK, they are within the jurisdiction of the UK for the purposes of protecting their privacy rights. So we have seen some movement in that regard that is laudable. Whether it's sufficient is up for analysis. We have also seen the development of the idea of positive obligations. As many of you know, human rights traditionally focused very much on negative obligations. Thou shalt not kill, thou shalt not torture, thou shalt not deprive an individual of his or her liberty, and etc. But increasingly, we are seeing human rights bodies develop the positive aspect of human rights, and that is you're not only required not to violate the right to life, you also need to take protective measures in order to protect individuals from criminality. or from other threats to their life or liberty or privacy. So for instance, environmental law is an area where we're seeing increasingly a propensity to adopt positive obligations. And I would say that we are seeing this increasingly, not still at a very significant rate, but we are starting to see human rights bodies develop this idea that you need to regulate technology. And what we have certainly seen is an increased appetite, especially in Europe, to regulate technology. And we have almost, I would say, an endless flood of regulatory instruments, right? So we have the DSA and the DMA and the AI Act and of course, the GDPR and the due diligence directive. I actually looked on Friday and I saw that there are currently more than 30 bills pending before EU institutions, all directed to regulating technology. So maybe you could even say that there is a regulatory overdose in the context of the EU. But this idea that states have a role to play in regulating technology is an idea that is certainly taking root. Again, there is still the question of whether Sweden can do this effectively with regard to Apple, right? Although even if the EU tells it to do so. But I would say that there is some movement in that direction, and this I think is on the whole fine. And finally, the business and human rights framework, which is, I would say, probably the most, in my eye, the most critical element of the existing framework, because it does deal directly with businesses. We are seeing attempts to beef it up. So as I said, the European Union has just passed a few months ago a new directive on corporate sustainability and due diligence, corporate sustainability due diligence. Yeah, so the corporate sustainability due diligence directive, which requires, it's not unique to the technology sector, but it would also apply in the technology sector and require companies to conduct human rights impact assessments, to undertake due diligence in order to deal with risks that come out in these impact assessments, and to provide remedies in the event that the risk had materialized. So we do have a framework, at least in the EU, that is more robust. At the UN, I would say that the situation is much less rosy. I mean, we do have awareness that that what we have, the 2011 UNGPs, are not good enough because they're soft law. They do not create legally binding obligations. Their implementation is rather weak. They also are quite minimalistic in terms of what they require companies to do. And there is an interest in upgrading them through the negotiation of a legally binding instrument on business and human rights. But this has been going on. This is a project that has been going on for many years, and it doesn't seem as if we are seeing the light at the end of the tunnel. So I would say there is some movement. So not everything with the existing framework is negative, but then you have the question, like I said before, whether how much mileage can you actually obtain through relying on this fundamentally system that was fundamentally created for other needs. So we do have this. So the problem of fit, even if we are bending and stretching and extending our framework, we still have a question whether the framework in and of itself provides us with the necessary solution. And against this context, I think we are seeing this new push, and now I'm getting to the generations, this new push towards a normative response. And the idea of a normative response basically stipulates we need a somewhat different human rights vocabulary. So it's not just a question of whether we can bend and stretch what we have. We need new elements. Mm-hmm. And some of the elements that we need would be institutional. And if I will have time, I can discuss them as well. But some of the elements will be normative. We need the new human rights vocabulary. We need to identify new human rights principles that have been specifically tailored for the challenges and the opportunities brought about by new technology. That does not mean that the existing vocabulary is useless. We will still use the existing vocabulary, but we will build upon it and we will complement it with this additional new vocabulary, and we'll try to combine the two. And in fact, although this is, and we may have a chance to discuss this, This is a project that is viewed upon with some degree of apprehension by many international lawyers, international human rights lawyers, because they consider this as a sort of an abdication of the existing framework and maybe putting in question what we already have. But I would say that this has been the experience of human rights law for many years, that we have our basic treaties, we have this ICCPR and the ICSCR, and on that we are building specific bodies of law. So we will build a specific treaty with a specific vocabulary for children, a specific treaty and a specific vocabulary for the rights of persons with disabilities, a specific vocabulary for specific crimes such as disappearances, etc. So I wouldn't say that this is a radical break from the traditional history of human rights, but simply application of this traditional logic to this new domain. So what are we seeing? We are seeing first this increased interest in states, but also at some level at the EU, with creating bills of rights or charters of rights. This is a very partial list. I mean, we have started seeing even more than a decade ago, internet bills of rights. Now the language is more centered around digital rights or AI rights. These are the types of charters. So these are typically guiding instruments. They are typically not legally binding instruments. They would typically be normative instruments that are supposed to guide both courts and also the state administration in the ways in which they operate. And some of these bills of rights deal with some of the rights that I will be alluding to momentarily. Some deal with, I would say, more mundane issues, such as some bills talk about access to high-speed internet as part of the rights that individuals within the country should have. There is not always clear separation between constitutional law, administrative law, private law. So the US bill, the Florida Digital Bill of Rights, is actually mostly consumer rights kind of instrument. Some bills of rights are more constitutional in their orientation. So this is one area. And I would suggest this normative approach that we can see in the national and in the regional bills of rights and in other projects that are emanating could be typified into three, what I call generations of rights. So when we are talking about the normative response, we can distinguish, and I'm using, of course, the language of generations, because within human rights law, there is this famous terminology introduced in the 1970s by Karl Vasek, who stipulated that human rights themselves proceeded through three generations, which some human rights lawyers don't like so much. I should say this idea of generations because in their mind it denotes hierarchy, but I think it simply describes different historical periods in the development of human rights, where the challenge was first the absolute monarchy, then the challenge was the Industrial Revolution and the need to deal with extreme poverty, and then the challenge was self-determination and the collective claims of groups to assert their place in international life. So it doesn't denote, in my view, in any way an hierarchy between these rights. So the three generations, I mean, the first generation that I would identify emanating from these existing projects would be reinterpretation. So we take existing rights and we reinterpret them to apply in a digital context. Now, sometimes the reinterpretation is quite simple, and I would say that Article 19 of the ICCPR is an easy case. It's an easy case for reinterpretation, partly because the drafters, in their wisdom, have made Article 19 what is called future-proof. So the language of Article 19 talks about any other medium, so any other media of one's choice. So the freedom of expression applies through any media, and it applies also across borders. So we have a lot of the problems that we have in thinking about new technology actually are not major problems here in freedom of expression, because the internet or other ways of communicating is through digital technology is a medium. And here I think it makes a lot of sense to talk about rights that apply offline, also apply online. There are unique challenges. And again, I don't have a lot of time, and I think we are starting to become pressed for time. So I will just say we do have problems, for instance, speed, scope, and scale. I mean, so if we're talking about harmful content, the problem could be more acute when we are communicating online than offline. And as a result, there may be different points of equilibrium between rights and limitations. And we may be more inclined to restrict ex ante harmful communications online than we might be offline, where we are trained as lawyers to prefer ex post restrictions. But by and large, these are variations around the theme. When we get to the next right, privacy, it becomes more complicated because privacy online has unique features that do not exist offline. So this whole idea of, for instance, privacy in the public space. This is something which in traditional privacy scholarship, this was a clear distinction between the private and the public. And now with technology, this idea of a face in the crowd, which was a way in which we effectively enjoyed some degree of privacy, even when we were in public. The technology requires us to reevaluate this idea and to extend privacy controls also to our public activity. Another example, data and metadata. I mean, traditionally, there's been a sharp distinction in domestic law between the letter, which is protected, and the envelope that is not protected. So what you write on the envelope does not have privacy guarantees. The state, for instance, is authorized to look at the envelope. In digital communication, it does not make sense because actually metadata, I mean data about who sent what to where, from what point in the planet, how long was the conversation, who did you call afterwards? This is sometimes much more important than the actual content. So we have to reevaluate the way we understand privacy. And I would argue it's even a more serious issue because the center of gravity of the right has moved from the right to be left alone, to have this sphere of intimacy, which the state does not intrude, to an idea that I can control my data, which is a very different set of interests. And today, I would say privacy is mostly used in civil liberties context. It's a way that I could exercise my freedoms, not be manipulated, but also not to be monitored in ways that would be incompatible with my ability to enjoy other rights, such as association, assembly. So the right has changed very much. You could say it's DNA. I don't know if it's possible, but it has become something very different and also something very grandiose. So that's, I would say, the first generation going to the limit. So we don't have time, but I will say that the more we go in that direction, in the privacy direction, there are increasingly legal pushbacks. Because there are questions about whether this is a legitimate act of treaty interpretation, whether it is sensible to create mega rights. If everything falls into privacy, the right to be forgotten is privacy, the right to human decision maker is privacy, the right to control data is privacy, then we are starting, it is becoming at some level unworkable as a right and maybe also illegitimate as an act of interpretation. And also, of course, we have part of the problem with first generation rights is that we have to, in a way, shoehorn into existing rights interests which could be much broader. So there is literature proclaiming that the right to internet access, that some maintain is a right, is part of freedom of expression. But this is a very limiting understanding of the right of internet access. Internet access is about expression, but it is also about social life. It's also about political life. It's also about employment. It's about education. So the idea that everything now would be shoehorned into freedom of expression is also probably misses to capture the essence of the thing. Now, second generation rights is the idea that, well, there are some fundamental interests that could be justified as human rights, because there would be a strong moral claim to support them. There will be a strong need to deal with an important problem. There will be also political support for them, but we don't have in the existing vocabulary, we don't have a good articulation for them. So I'll give you, in the interest of time, only one example. And this is an example I'm working now to edit a book on. And that is the idea of the right to human interaction. The idea is this is increasingly an interest that individuals are articulating. So we have already recognition in the GDPR for the right to a human decision maker, the right that an algorithm would not take important decisions about our lives. But we are increasingly hearing concerns, for instance, from the caregiving institutions and from patients in a caregiving context, that they would want to be treated by a human physician or by a human caregiver and not by a robot. I mean, and the same questions are bound to arise in educational settings, whether we would have our children or grandchildren, probably not even, grandchildren would, I don't know what would happen to them in terms of technology, but do we have a right to a human teacher? Or to see even a human being in our own university education? I mean, these sort of issues are going to arise with increased frequently, and there are those, and I'm among those who say we would have to discuss seriously whether we need a right to human interaction. And this is something we don't really have the existing vocabulary in current human rights law to articulate this sort of need. And the claim you can see on the slide, there are other ideas that would it would be very hard to anchor in existing human rights. So if we take seriously the need to adjustment, we might as well go and simply articulate new rights as we have done over the years in other contexts. And finally, the third generation, and with this I will conclude, takes into heart this idea that we need also to expand our list of right holders and duty holders. So in terms of right holders, there is a question whether we would want, in the same way that we conferred upon corporations rights, do we want to confer rights upon digital persons? Given the fact that many of us would have a physical personality, but also a digital personality. Sometimes the digital personality could be traded. Sometimes it operates in a metaverse in parallel to our existence and engages in activities that we may be aware of or we may not be aware of. There is this whole afterlife industry of perpetuating our digital existence after we are gone. And that raises practical issues as to who has the right to speak on behalf of these digital creatures. I'm not sure that this is the most important thing at this point in time, but it is an issue that is going to arise. The other point, of course, is much more important. The idea that some of these companies exercise de facto powers of governance, powers of standard setting, of dispute resolution, of law implementation, and therefore we should find ways to implement on them human rights in a more direct ways. I think the oversight board, which I mentioned before, with all its imperfections, is an important step in acknowledging this idea that if Meta is exercising so much political power over individuals, it has also to accept certain rule of law safeguards, including the ability to appeal its decisions. So concluding remarks. We are seeing a process, and that process exists already, regardless of my talk and three generations, and we are seeing digital rights emerging, such as the right to be forgotten, the right to a human decision maker, the right to internet or high-speed internet access. They already exist in domestic law, in regional regulation, in standards set by companies themselves, and we are seeing a gradual emergence, or the gradual migration of these digital rights into the world of digital human rights law. So we are seeing, for instance, in the famous Casteja case, the case involving the right to be forgotten, the court actually links the digital right to be forgotten to the Charter of Fundamental Rights. And the same we have seen recently in another case by the European Court of Justice, the Shufa case involving the right to a human decision maker, which has been linked again to the Charter of Fundamental Rights, to privacy, and to the right to data protection, which is under the Charter of Fundamental Rights, a fundamental right in and of itself. So this is already happening. Whether we like it or not, I think we should like it. I think it's a good way. We should, of course, ask ourselves, how far do we want to go? And we need to justify this movement, because new rights always have to be justified. And I've mentioned some of the elements that need to be looked at when we are justifying new rights. There are still the bigger questions. Is human rights law a suitable vehicle for advancing this set of concerns? Or maybe we should advance them through technology itself, through regulatory instruments, through some other, maybe private law, consumer law. So is human rights law the answer? I have no strong position on this. I put it as a question. I think, personally, I tend to think it's part of the solution. It's not all the solution. And do we need new digital human rights or AI treaties? Here, my sense is yes. I mean, if we want to build, to maintain the relevancy and effectiveness of human rights law, we need to beef it up with new normative instruments, despite the many difficulties of doing this. And I will note, maybe with a sign of optimism, the fact that the Council of Europe was able to reach in a relatively short time, less than 4 years, to reach a new treaty on AI, and AI on AI human rights, rule of law and democracy. Although the treaty doesn't say much, and that's probably why it was concluded fastly. But that in and of itself is an encouraging sign. So states in this area seem to have some appetite for international lawmaking that they probably do not have in other areas of international law. Thank you very much for your attention.